Sowore, a human rights activist, is here in court over the DSS allegations that Sowore, on or about August 25, 2025, did knowingly send a message by means of a computer system or network through his official X, formerly Twitter handle page at Yele Sowore. In the message, Sowore was alleged to have posted the following tweet. This criminal, as the official ABAT, actually went to Brazil to state that there is no more corruption under his regime in Nigeria. What audacity to lie shamelessly. He is accused of having committed an offense of cyber stalking contrary to section 24 subsection 1b and 24 subsection 2a. B, and C of the Cybercrimes Prohibition Prevention Amendment Act of 2024 and punishable under the same section. The prosecution lawyer applied that the names of the second and third defendant be removed and Justice Umar struck out X and Facebook from the charge. Kehinde therefore pleaded that the two count be read to Sowore. Counsel to Sowore, Marshal Abubakar, did not oppose Kehinde's application that the charge be read to his client for him to take his plea. After the counts were read to Sowore, he pleaded not guilty, and Abubakar prayed the court to allow Sowore to continue to enjoy the earlier bail granted to him, and the court granted it. The DSS lawyer then informed the court that the prosecution witness was in court to testify in the case and that they were ready to proceed. But Abubakar told the court that they were not ready to go on with the case. The lawyer submitted that in the proof of evidence attached to the charge, the names of witnesses were listed, but no single name was mentioned in the case. Besides, Abubakar, who said that no single testimony of the witnesses was attached, argued that these violated Section 36, subsection 6 of the 1999 Constitution. He further submitted that he needed adequate time and facilities to prepare their defense. But Kehinde disagreed with Abubakar. The senior lawyer submitted that the provision of ACJA, as quoted by Abubakar, had no bearing in the instant. Besides, he says that reliance on this provision of the law is grossly misconceived and an insult to the court. Kehinde said the defense was at liberty after the witness must have given the evidence to ask for a stand down or an adjournment to cross-examine their witness. He said that Abubakar's submission was a ploy to delay the trial, urging the court to discountenance the argument. After taking all the argument, Justice Umar adjourned until January 22nd for definite hearing.
The president has not complained that he's not a criminal. He didn't complain to anybody. It is busybodies at the DSS who have nothing to do at the time that the country is in need of their intelligence expertise, so-called, that they went around trying to please the president. Maybe they have some money left out there for lawyers, and they just want to find some people to give briefs to, And the last thing I'll say is that we have been through this nonsense before. Malami was the architect of this kind of foolish lawsuit. Look at where he is today. In fact, when we leave this place today, we want to go and help to bail Malami out of the... Yes, at Kuje prison. We are planning to go there because he's entitled to not only the bail is being granted, but the freedom that the bail had, Hopefully, we will still be able to find him there at Kuje prison where he's been hiding. But we are not mocking him because we don't play with fundamental human rights.
This is the first time in a long time that we will see that the government will file a case in court and they would not list any witness that they intend to prove their case before the court. No single witness was listed in the proof of evidence in court today. They also did not inform us ahead or serve us in line with the principle of front-loading the allegations of their witnesses against us in court today. It was on that basis that we objected to the arraignment today, having failed to comply with the requisite constitutional and statutory mandates. Section 36 of Section 6B mandates them to avail us every facility and time required to prepare for our defense.
Every attempt, every opportunity, every loophole to waste the time of the court and they said, oh, they need to know the name of the witnesses we are fielding, they need to see the witness statements and all that. And we told the court that what the law requires us to do is to list our witnesses, the documents we want to tender, and a summary of the case we are bringing before the court, which we did. But the court, in order to ensure that there is no complaint of anybody saying that his right to fair hearing has been breached, said that we should oblige them with a summary of the case our witness will be coming to tell the court. We believe that at the end of the day, Nigerians will see very clearly that the right to fair hearing, the right to free speech is not unlimited, and you do not have the right to insult the president, who is the face of this country, on social media just because you are looking for attention or looking for whatever grant from your sponsors.
Abuja, Godwin Amundi, Rapid Television News.